The Supreme Court just sidestepped two major Second Amendment gun cases. But don't mistake that for neutrality. This Supreme Court is gearing up to expand the Second Amendment even further, and we need to talk about it. I'm Eliza Orlins, career public defender for 15 years in Manhattan, and I want to break down this Supreme Court's decision not to hear these cases and what it means for all of us. So this week, the Supreme Court denied cert, meaning they decided not to hear the challenges to two different laws that came out of Maryland and Rhode Island. In Maryland, there's a law that bans assault-style weapons like AR-15s, and in Rhode Island, there's a law that bans high-capacity magazines, anything over 10 rounds. Gun rights activists have argued that these two laws are unconstitutional based on this case called Bruin that the Supreme Court decided back in 2022, which said that gun laws have to be consistent with the nation's historical tradition of firearm regulation. In order for a case to be heard by the Supreme Court, 4 judges need to agree to grant cert. In this case, they only had 3. Justices Alito, Gorsuch, and Thomas would have granted cert, and Justice Kavanaugh respects the denial, but his opinion is troubling. Kavanaugh didn't dissent from the decision, but he did write separately in order to criticize how the lower courts are handling these cases. In this highlighted portion, you can see he says, although the court today denies certiorari, a denial of cert does not mean that the court agrees with the lower court decision or that the issue is not worthy of review. The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeals. And then at the end of his statement, he says, opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for cert will likely be before this court shortly, and, in my view, this court should and presumably will address the AR-15 issue in the next term or 2. Of course, Justice Thomas writes a lengthy dissent in which he says, I would not wait to decide whether the government can ban the most popular rifle in America. That question is of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. So what's the translation of all of this? Well, the far-right flank of this court is not saying no, they're just saying not yet. The court is just waiting for another case to come up that enables them to strike down gun laws. Meanwhile, lower courts are all over the map. Some are upholding restrictions, some are throwing out restrictions that have been in place for decades, laws like prohibitions on domestic abusers, ghost guns, and even waiting periods. And this chaos is a direct result of the Supreme Court's decision in Bruin, a decision that ripped out decades of precedent and replaced it with a vague cherry-pick-your-history test. So this week's decision isn't a victory for gun safety, it's a delay. The court is dodging while the country pays the price. But make no mistake, this Second Amendment showdown is coming. And with this court, the stakes could not be higher. So if you want to understand what's really happening here, make sure you're following me for more. Don't just rely on the headlines, because the legal system doesn't protect public safety by default. We have to fight for it. Thanks for being here.